Hello, everyone, and thank you for joining us for Planning with Purpose, Essential Documents for Estate Planning with our speaker, Wendy Goffe, partner at Ogden Murphy Wallace. I'm Cindy Sherrick, Director of Gift Planning at Seattle Foundation, and we're delighted that you're here. Wendy has a wonderful presentation planned that will help you explore how to put your values into practice through thoughtful estate planning. Our Planning with Purpose series is designed to provide philanthropically minded individuals and professional advisors with practical insights and charitable planning strategies. We offer 2 complimentary webinars each year focused on estate and gift planning topics. If you'd like to receive future invitations and related resources, please take a moment to complete the brief survey that will appear at the end of today's webinar. I'd also like to extend a special welcome to Seattle Foundation's fund holders, our change makers who have included Seattle Foundation in their legacy plans, and the many professional advisors joining us today. Seattle Foundation is honored to partner with more than 1,400 philanthropists on their giving journeys, including nearly 300 individuals and families who have chosen to create a lasting legacy through future gifts. Thank you for being such an important part of our community. Whether you have already have a fund at Seattle Foundation or are joining us for the first time, we're always happy to be a resource for your charitable giving questions and planning. Now, to help get us started, I'm going to cover a few quick housekeeping items. First, everyone is muted and cameras are off to limit noise and disruption. We are recording today's presentation and we'll send a link to that recording as a follow-up. At the end of today's program, we will have time for Q&A. So for any questions that come up during the program, please use the Q&A button at the bottom of your screen, or it might be at the top if you're using an iPhone or an iPad. We'll get to as many questions as possible during our time. The event also has a live transcript and closed captioning. If you'd like to turn on this feature or change the size of the closed captioning, you can do so by clicking Live Transcript at the bottom of the Zoom window. Finally, when you sign off today, you'll be prompted to take a quick survey about your experience. Please take a few moments to complete this. We read every piece of feedback we get, and it really helps us shape future events. All right, let's get started. It's my pleasure to introduce today's speaker, Wendy Goffe. Wendy is a partner at Ogden Murphy Wallace and has more than 30 years of experience advising individuals and families on estate planning, probate, and charitable giving. She is a nationally recognized author and frequent presenter on estate planning and nonprofit topics. Many of you may also know Wendy through her long-standing involvement in our community. She's a former member of Seattle Foundation's Professional Advisor Council. She's a volunteer with Girls on the Run, and she's a dedicated advocate and pro bono supporter of Seattle's nonprofit sector. We are delighted to have her with us today, so please join me in giving a warm welcome to Wendy Goffe.
Thank you, and good afternoon, everyone. I just have to tell you that yesterday I was in Chicago working, and today I'm at a friend's cabin in Michigan, and I have been so worried that I was going to get the time zones wrong. So just the fact that I am on camera when I'm supposed to be is I'm halfway there. So first I want to thank the Seattle Foundation during Make a Will Month for hosting this presentation as a public service. I can't tell you how many people I've told to take advantage of this as a free opportunity. So it's a great opportunity for a lot of people. Today, we're going to talk about estate planning, what it is, why everyone needs it, regardless of wealth, and how you can use your estate plan to protect the people you care about and the causes that you care about. I want to emphasize at the outset that this presentation is general information. It's not legal advice. Every person's situation is different, and the right plan depends on your particular family, your assets, your values, and the laws that apply to you. My goal is to give you a framework for thinking about these issues so that you can leave feeling empowered but not overwhelmed. So first, what is estate planning? Estate planning is not reserved for wealthy individuals, and I can't stress that enough. If you own a home, if you have a bank account, if you have children, if you have pets, if you care about what happens to you, if you become seriously ill, you need an estate plan. At its core, estate planning is about two things. First, deciding what happens to your property and your responsibilities after you die. And second, and this is the part people often overlook, deciding what steps are in it for you, what steps need to be taken if you're incapacitated during your lifetime. I often describe estate planning as a gift to your family. When you put a plan in place, you spare your loved ones not just you spare them having to guess as to what you might have wanted. And you need this is not financial planning and it's not retirement planning, but you need to coordinate those two things with your estate plan. So I find that clients are happiest with their estate plans, not when they're complex, not when they're clever about tax strategies, but when they're confident that the plan carries out their values and their wishes, and they feel that their loved ones will be taken care of. And not in the clever tax way, but that they're going to transmit their values and their wealth. So, what are the goals of estate planning? For most people, the priority is financial security for those they love, a spouse, a partner, children, grandchildren, and your pets. Pets are important. And this might be making sure a surviving spouse can maintain their standard of living or making sure children have resources for education and care. It might mean protecting a child who's not good with money or making sure a disabled child will have money available for the rest of their life and in a way that won't disqualify them from benefits they might otherwise be receiving. Another common goal, and the reason I think we're probably all here today, is that we want to leave a charitable legacy. And you don't have to be wealthy to be able to leave a charitable legacy. Many of my clients feel strongly about giving back to the community, and an estate plan is a wonderful way to do that. And it can be done in a structured, tax efficient way. If you don't have a taxable estate, you don't need a tax efficient way, but for a lot of people, that does make sense. So I'll talk a little bit about that later in the presentation, different ways that you can leave money for tax planning purposes or just to be able to leave money. Clients also want to reduce or defer estate and income taxes where possible. Nobody wants to pay more in taxes. There's nothing wrong with paying tax when it's owed, but if you can provide for your loved ones and charity rather than paying more tax, there are opportunities and legitimate planning tools. So I don't ever want to have the tax tail wag the dog. It should inform your decisions, but it shouldn't drive your decisions. And your plan should reflect your values and your family's needs. And we optimize for taxes within that network, that framework. So, estate planning also gives you control over the ultimate disposition of your assets. And here's a common example. Suppose you're in a second marriage. You want to provide for your current spouse during their lifetime, but you also want to make sure that whatever is left over ultimately goes to your children from a prior marriage. Without a plan, that can't happen. But with a plan, a well-drafted trust can accomplish exactly that. You can have the money held in trust for your surviving spouse, and then at your surviving spouse's death, it can go to your children. In some circumstances, it can be held in trust for all of them simultaneously. Whether or not that's a good idea is a topic for another day. Creditor protection is often a goal, and properly structured trust can shield assets from a beneficiary's creditors, including in a divorce. And this is particularly important for families with significant wealth or beneficiaries in a high-risk profession where they don't want to expose their family's wealth or maybe a family business to their own possible risks. And finally, a good estate plan reduces post-death complexity and expenses. When I meet with families after a death, the ones that had a thoughtful plan and in place often grieve differently. It's not that we can eliminate grief, but we can eliminate some of the anxiety about what happens after death with assets so that they can grieve and not just have financial anxiety. There's enough. That's enough. Um, so before we go further, I want to define some key terms, and you don't need to memorize these. It's in your materials, but they will have a bearing on what I'm going to say for the rest of the conversation. A decedent is simply a person who's died. A testator or testatrix, although I try and just say testator, is a person who makes a will. Um, Property in estate planning can mean a number of things. Real property, real estate like your home, personal property, cars, jewelry, intangible property like stocks, bank accounts, and then there's intellectual property. And then we also have now digital property, which could be cryptocurrency or just the photos that you store on the World Wide Web somewhere. A trustor is the person who settles a trust, also can be a grantor or a settlor, lots of different names for the same thing, the person who creates a trust. A trustee is the person who manages the trust for the benefit of the beneficiaries. And I have to confess that I have a degree in medieval history, so I like to talk about this and amortize that education because trusts and banking all originated in the Crusades and were developed during the Middle Ages when Crusaders needed to leave their property in trust while they went off to fight the Crusades. And then out of that came the Italian merchant families, and I could go on forever. But if you're ever interested, email me and I'll give you some great resources and you can go down that rabbit hole on your own. Think of the trustee as the steward of that money. And a donor is a person who makes a gift during life, and a donee is the person who receives that gift. And it could be a charitable donee or an individual donee or donor. A testamentary trust is a trust that comes into existence through your will or upon your death. It does not exist during your lifetime. It doesn't get set up until after someone dies. An inter vivos trust, by contrast, is a trust you create during your lifetime. The most common example is a revocable living trust, which I'm going to talk about a little later. Per stirpes, you might hear that used, or the term by right of representation is a distribution concept that comes up frequently. It means that each branch of the family receives an equal share. So if I have 4 children, and each of the children have a different number of children. So I have different numbers of grandchildren through each child. It doesn't matter how many grandchildren there are. My estate is divided up into 4 shares, and then eventually that share will get divided up among that child's descendants. So that's per stirpes or by right of representation. I don't want to get too in the weeds, but per capita just means an equal share for every beneficiary. A contingent trust is one that comes into existence if a certain condition is met. Like if I have children under the age of 25, I leave a contingent trust for those children until they're age 25. And finally, for legal purposes, in community property, you can give away your half of the community and all of your separate property if you're married, or you can give away all your property if you're single. And I think I'll just move on to the next slide. So let's talk about what your estate might actually include, because different assets get transferred following different rules, and the planning can get complicated. As I mentioned earlier, your estate could be your home, your furnishings, real estate such as a vacation home, farm, rental property, timeshares, intellectual property, royalties. You might have stock, bonds, mutual funds, other securities, bank accounts, brokerage accounts, CDs, cash, all of this is part of your estate, including life insurance. And for some reason, people often think that life insurance isn't part of their estate, but it is. And each of these assets passes differently, possibly. So one thing I want to emphasize is that you need to think about each asset differently, because some assets pass by beneficiary designations. Some can pass by beneficiary designations, but also can pass by will. So we need to keep those straight in order to make sure your plan carries out what you want. So if you have life insurance, IRAs, 401ks, profit sharing, deferred comp, and annuities, those things pass by beneficiary designation and don't necessarily pass under your will. And if you don't have a beneficiary designation, the plan says where it goes. So you need to know what your beneficiary designation says, and that's something you should check on. Artwork, coins, stamps, those things will pass under your will. Tangible personal property, cars, jewelry, boats. In Washington and in most other states, you're allowed to leave a list separate from your will that says where that tangible personal property can go. So when you're doing a will and you're paying your lawyer to do the drafting, you don't have to list out all those things, that the mementos that you might want to go to people. You can do that on a separate list and it's stored with the will. And I tell clients that sometimes the first thing that a family does after someone dies is they start thinking about who gets what. And it isn't necessarily the value, it's the importance of things. And I got my mother's frying pan that she used on Sunday mornings. And I later found out that you're not supposed to use that kind of frying pan because it has arsenic. So I can't even use it. And I found the same one without arsenic for $9 on Amazon. So it's not the value, but the memories. And if I find among my clients that if they have that thing that conveys the memories, the anxiety goes down by a lot. So I encourage people to think about what their kids might find valuable emotionally and leave it to them. And even though your kids can divide everything up in equal shares and it doesn't have a lot of value, there's emotional value. And there's emotional value in letting your kids know, I see you, I know what was important to you. The other thing just to keep in mind is that wills don't control everything, that you do have things that pass by beneficiary designations like your IRA, your 401k, and it's important to review those things frequently. So I mentioned community property. Let me go back to that. Washington is one of 9 community property states, and this has huge implications for estate planning. The basic rule is that title does not determine ownership. If married, all property you hold at death is or divorce is presumed to be community property, and then you have to overcome that presumption to prove that it's separate property. Maybe you acquired it by gift or inheritance, that's separate property, or you brought it into the marriage, that's separate property, or you brought it into the marriage and you used that money to buy something else, that's still separate property. That you can give away 100% of, but community property you can only give 50% of. And this isn't very nice, but I have seen people give away half their community property to someone other than their spouse while they're married. And that, if they're married and their spouse now finds out that they're co-owning the house with another person, that's not a good result. And I try not to be a part of that. Separate property includes gifts, inheritances, property owned before the marriage, but only if it's kept separate. And if you inherit money and then put it in a joint checking account and use it for household expenses, you've probably commingled it and converted it from separate property to community property. So if you want to keep your community property, your separate property separate, it's important not to commingle and get some advice on that. Other kinds of separate property that we don't see a lot of, but it's out there, are federal death benefits and personal injury, pain and suffering awards. So record keeping is important. And if you want to maintain the separate character, let me have a drink here. If you want to maintain the separate character of inherited property, you should keep it in a separate account. Planning for disability is really important. And this is a topic I can't stress enough. Incapacity planning. Most people focus entirely on what happens after they die. But if you don't plan for incapacity, you may be incapacitated without someone to manage your finances or your medical decisions and not having had finalized your estate plan. So we all need to think about what happens if tomorrow we have a stroke, car accident, develop dementia. Who pays your mortgage? Who communicates with your doctors? Who makes sure your bills are paid and your investments are managed? And because our finances can be managed through our phone, and a lot of that, I've bought houses for clients on phones. Using DocuSign. I've sold assets using DocuSign on my phone, and we have access to our bank accounts. If you don't have access to your phone, because maybe you're just on an exotic remote island vacation, you are technically financially incapacitated. And if someone needs to do something like sign a DocuSign and you're not available to do that, you need someone to step in for you. So it's not just disability, but just no access to the phone. And so for that reason, incapacity planning can be more important than death planning because it lasts for your entire lifetime. Every adult, regardless of age or wealth, needs to think about a durable power of attorney for financial matters, a durable power of attorney for healthcare decisions. If you trust the same people to do both, you can have one combined document, but often people have a different cast of characters for both. A directive to physicians, which is sometimes called a living will or a healthcare directive, and that's the document that says I do or do not want nutrition or hydration if I'm in a permanent vegetative state. And then you need a document that states your wishes with regard to disposition of your remains. I want to underline and highlight that these documents are especially critical for unmarried persons and unmarried partners because the law does not recognize somebody in a position of authority if you're not married to them or you haven't named them in a document. So Washington does have a domestic partnership act, and I'm not talking about that. That applies where you actually register and one member of the couple is over the age of 62. That's sort of, we used to call it, I was one of the drafters of that bill, and it was sort of a marriage light. That's not what I'm talking about here. So I'm just talking about unmarried couples who live together. And if that happens, your partner has no legal authority whatsoever to make decisions for you, visit you in the hospital, or access your accounts. And the law doesn't presume anything for unmarried couples. So you have to express your wishes explicitly. A durable power of attorney, I'm just going to circle back and give you a little bit more detail about those documents. A durable power of attorney for financial matters allows you to name someone you trust as your agent to manage your financial affairs if you can't. The word durable is important. It means the power of attorney remains effective even if you're incapacitated. I like to have these documents effective immediately because if I'm lucky enough to be on an exotic vacation and can't use my phone, I'm not incapacitated, but I need someone to step in and help me out. And it's sort of a litmus test. And I don't understand the psychology, but I've had people say, I don't trust that person to be named unless I'm incapacitated, which leads me to ask, how do you trust that person if you are incapacitated, but you don't trust them right now? I can't answer that, but it is a test for me. And if someone says I don't trust them while I have all my faculties, I generally think it's a bad idea to name them at all. And so without that word durable, it's not a power of attorney that someone can use when you're incapacitated. That's a different kind of power of attorney that you might see in a business situation. The medical power of attorney, sometimes called a healthcare power of attorney or healthcare proxy, allows you to name someone who will make healthcare decisions. And these are not decisions based on their values. They're based on them standing in your shoes, doing what they think you would do in that set of circumstances. So it's really important that this is someone who understands your values and can carry out your values even if they're not shared. This is the person who's going to talk to your doctor, consent to or refuse treatment, and make decisions about surgery, medication, possibly end-of-life care. And without this kind of document, without a healthcare directive, people end up in court having the court appoint a guardian to make those decisions. It's a long, protracted, sometimes expensive process. So it's much better to have a document in place. How do you choose people to carry out these roles? Um, someone, it should be someone who cares for you, but that's not the only criteria. Ideally, it would be someone who sleeps with their phone. I don't advocate for sleeping with your phone, but if you have someone and they're always available, that's kind of nice. Choose the person who's most likely to honor your wishes, even if those are difficult to carry out and may not match their values. Look for someone who remains calm under pressure, communicates well with physicians and family members, and is willing to ask hard questions and can advocate for you if they personally would make a different, even if they would make a different decision. And nobody's going to fit all of those characteristics. That's the unicorn, but the more characteristics you can find that are on that list, the better a fit. And they need to have time. So the person with all those characteristics that works too many hours already probably isn't the right person. This is a very different skill set than actually being your doctor or being your financial advisor or CPA. They don't have to have those skills. They just need to be able to ask the right questions and get the right answers. One of the biggest, earliest states that I worked on, the testatrix in this case, named her hairdresser, and her hairdresser uh, asked all of his clients for referrals to accountants, financial advisors, lawyers, and that's how he found his team. And he let his team work together, and he stepped in when he needed to, and when he didn't, he went back to doing hair, and everybody was happy, and it ended up in a good result. So he knew how to delegate and find the right people to delegate to. He didn't need to know how to carry out all those tasks. And the other thing that's really important is conversations. It's important to have conversations, ongoing conversations with the people who are going to carry out these roles so that they do understand your values and they're not left guessing. And to that end, the healthcare directive slash living will is the document that expresses your wishes with respect to certain decisions, not all. And they can use that to carry out your wishes. So that would be end of life decisions. There's also a HIPAA authorization, and that's the document that allows someone to communicate with your physicians and your physicians to communicate with them. We used to do that as a separate document. That's now included in the healthcare directive most of the time. Other estate planning matters to consider. There are lots of other issues that deserve attention. For parents with minor children, they need to name a guardian, and that is done in their will. And I think that for parents with young children, naming the guardian and changing the name of the guardian is the thing that precipitates estate planning and changes in estate planning more often. And you also need to name someone to carry out disposition of your remains, and that could be burial or cremation, or now we have in Washington and a couple other states, including Illinois, natural organic reduction, which people refer to as composting, which has become quite popular and is more environmentally sound. You can also express whether or not you want a funeral, memorial, celebration of life, Viking send-off, ashes launched into space. You can express all that. And then there are cohabitation agreements, prenuptial agreements, postnuptial agreements, agreements that clarify the character of your property in a relationship. That's all part of estate planning. I won't talk about that today. Other things that we do in estate planning is gifts during life. So those can be used strategically to reduce estate taxes because we don't have Washington gift tax, but we do have Washington estate tax, and I'll talk about that in a minute. People do gift planning during life. Special needs trusts are trusts that are set up for beneficiaries with disabilities so that they can have access to the money for some things, but not be disqualified from public benefits, because nobody's going to send me a thank you note for drafting a trust that does that. It's very highly specialized. Organ donation is another decision that you need to make during your life, and sometimes that's done in estate planning documents, sometimes it's done on your driver's license. Ideally, you would get it done in both. When do you change estate planning documents? Major life events. Some people say every 3 years. If you haven't had any major life events in the last 3 years, it probably isn't necessary. But if you get married, divorced, lose a spouse, win the lottery, retire, you've had a great change in wealth, new beneficiaries, new grandchildren, those are times to revisit your estate plan. Changes in the law are also relevant. Those are most relevant when there are big tax changes. If you don't have a taxable estate, you don't need to worry about that. And choosing fiduciaries, I'm going to skip that because I've already talked about that. You need someone who's not a procrastinator, someone who understands legal deadlines aren't approximate, they're real, and they have financial penalties. So choose someone who gets stuff done. Washington estate tax. I'm going to say a little bit about that. Not very exciting, but it's easy to have a taxable estate in Washington. The exemption is $3 million. And for people who've worked, put a lot of money away in a 401k and own a house, it's not hard to meet that $3 million threshold. The rates range from 10% to 20%. We did have a 6-month period where they were at 30%. That came back down, and the exemption is now at $3 million. There's a federal exemption as well. That exemption is $15 million. And if you exceed the federal exemption, you need adult supervision and legal advice. So I'm not even going to talk about that because it's too big of a topic. But I am going to talk about charitable giving in estate planning because anybody can do that. And one of the most rewarding parts of my practice is assisting people help them align their values and their estate planning. And it's not about the big check. It's about being thoughtful as to where you leave your money. It allows you to leave a legacy and convey your values to your family, and allow your family to continue carrying out those values. So, community foundations like the Seattle Foundation, our host today, offers a range of professionally managed giving options that make charitable giving really accessible at many wealth levels because those funds are already dedicated to certain causes. So you don't need to set up a fund to carry out your wishes. There are scholarship funds, there are all kinds of different funds with different purposes, and you can contribute your $10 to it and it'll make a difference, and you don't have to spend money on the infrastructure. Charitable giving tools, the simplest is an outright gift. We call that checkbook philanthropy, cash, but you can give securities in real estate or other property. You get a deduction, and you can avoid triggering capital gains if you give appreciated assets. So you can give appreciated stock to a charity and you get a deduction for the full fair market value. They get the full fair market value and you don't have to pay capital gains. If you were to liquidate that stock and give the proceeds, you'd have to pay capital gains. So there is that ability to maximize and leverage your donation. The other thing is a donor advised fund, or people call them DAFs. I used to be opposed to DAF, but I use the acronym now. It's become enormously popular. You contribute assets to a fund and you receive an immediate charitable deduction the year of the contribution. But going forward, you can tell the charity where to send those funds. So I'll just share that we have a donor advised fund, and we give family and friends the opportunity to suggest where money goes. So it's a great way to teach people about philanthropy, sort of move them along in the process, encourage them to come prepared to tell you about the charity that they want money to go to, and then you tell the fund administrator where to send it. We like to give people a bad time, but we always say yes. There's also something called the qualified charitable distribution. And this is kind of a niche thing, but for those over 70 and a half, you can roll a certain amount of money of your required minimum distribution to charity from your IRA. And it's a tax advantage rollover. It goes straight from your IRA to charity. It's not included in income, so you don't get a deduction. But in the end, you're able to give more than if you took it into income and then contributed the money. So this year it's $111,000. You can't roll that money to a donor advised fund. And for the last couple of years, there have been discussions about maybe the law would be changed, but it doesn't look like that's going to happen this year. So you have to roll that money directly to an operating charity, a hospital, Girls on the Run, a museum, a library, but not a donor advised fund. There are lots of other sophisticated charitable giving tools, and just because we're limited on time, I'm going to skip those, but you can have charitable gifts in your will, and you can name a charity as beneficiary of your IRA or 401k. And the advantage of that, if you have a taxable estate, is that the money goes directly to charity and avoids income tax and estate tax. If you have a federally taxable estate, an IRA could be subject to federal estate tax, Washington estate tax, and income tax, which could be over 70% or 80%. So having it go directly to a charity leverages that money. There are a number of different community fund types. I'm going to skip over that. And I'm going to talk about what is probate, because people hear the word probate and they panic. And probate is not a scary thing. Probate is just the process of entering the will into the court. And Having said that, in some states, it is more involved than in others. So I practice in Oregon, and in Oregon, it's a different thing. You want to avoid probate. If you live in California, you want to avoid probate. But in Washington, it's not important to avoid probate. Probate is inexpensive. If you have a complicated estate, your estate administration is going to be complicated anyway because there's an estate tax return and everything needs to be valued. And avoiding probate or not avoiding probate doesn't change that. For some people, it's important to avoid probate if they're a celebrity and they need privacy. They don't want people to have access to their wills, but we don't file inventories in the court. So if you just say, I leave everything to my spouse, that's not tipping your cards too much. There are a lot of assets, as I mentioned in the beginning, that don't pass through probate. Those are non-probate transfers. So even if you do have a will, your will doesn't cover everything. It doesn't cover your life insurance, IRAs, 401ks, annuities. Those pass by beneficiary designation. And if you're married, it gets more complicated because if it's a community property asset, your spouse already owns half of that asset anyway. So if you're married, you usually leave those assets to your spouse. So from the outside, it appears that your beneficiary designation covers 100%, but it actually doesn't. It covers 50%, and your spouse already owns 50%. And that brings me to multi-party arrangements like joint tenancy accounts. Sometimes parents will think that they're creating some flexibility or they're making it easier on everyone by naming a kid as joint tenant on an account. But that means that at their death, the money goes to that kid. And then it's incumbent on the kid to say, yeah, actually, that was only for convenience, and really, I'm supposed to divide it up among you, my siblings. And we don't very often see that. We also see parents or grandparents where they might have 8 kids, 8 grandchildren, and 8 accounts, and they name a different beneficiary on each account and think that that's going to avoid needing a will and make everything easy. Except during their lifetime, they might spend down one or more of those accounts, or they become incapacitated and the person who has power of attorney knows that there are different beneficiaries and strategically spends down some accounts and not others, or even changes those accounts and combines them and gets rid of beneficiaries. So there's a lot of hanky-panky that can go on. While joint tenancies appear to solve a lot of problems, they can create a lot more. So I try and avoid them unless you have one beneficiary and one account. Revocable trusts do avoid probate, and we do use them to avoid probate in places like California or Oregon. People who watch Susie Orman think that they need a revocable trust, and I got a nasty email from some clients' kids last week who were upset that their dad didn't have a revocable trust, and it's not the default in Washington, and it is the default in other places. But I would feel bad charging someone to do a revocable trust to avoid probate when you're spending money to accomplish no really good end. And it looks like I'm running out of time. I want to make sure that I have time to answer questions. Post-death administration involves probate if there is a probate. Otherwise, there's an estate tax return that needs to be filed if your estate's more than $3 million in Washington, and all assets need to be valued. And there's no way around that. No amount of probate avoidance avoids having to value assets, even if your estate passes to a spouse, which would be tax-free, so there's no tax. If you have an estate that exceeds the tax limits, you have to file an estate tax return. So, I think one of the things I want to leave you with is just check your beneficiary designations and update your will if you haven't done that recently. And if you don't have one, you need one. And think about how you want to convey your values to your heirs. And if leaving money to charity strategically or just through your checkbook would help convey those values. And circling back to the donor advised fund, you can name your heirs to continue handling the donor advised fund after you're gone so they can be a part of your charitable giving, see how you give during your lifetime, and continue to do that at your death. So thank you for your time and attention, and I hope the presentation has been helpful in understanding what all goes on to estate planning. And with that, I will take questions.
Great. Thank you so much, Wendy. Time for Q&A. Don't forget to put your questions in the Q&A box. We're going to get to as many as we can. I do have a great one to kick us off from Brian Burgess. He says, what is the best way to orchestrate durable financial slash healthcare POA appointments for a revocable living trust when the grantor beneficiary trustee is aging and facing decline with no immediate loved ones around?
Make younger friends, lots of younger friends. Seriously, I have clients who name people from like their mahjong group or their bridge or poker group. They intentionally get involved in social activities that involve younger people, and that's a great thing. If you don't have that, there are professionals out there that serve in that role.
Great. Um, how about a question that was sent in advance? What are the best assets to leave to nonprofits as opposed to children and grandchildren?
Retirement accounts are the first asset that I would think of to leave to charity because, as I said, if you left a retirement account to a person, they would, at a minimum, unless it's a Roth IRA, they would have to pay income tax when that money comes out. A charity can take that money out and not have to pay income tax. If you have a taxable estate, then your estate would have to pay tax on that IRA or 401k, whereas a charity doesn't. So that would be the first asset. Next, and I didn't really talk about this, but capital assets, stocks, houses, get a stepped up basis at death. So the capital gain goes away. So you can leave assets in your will. You don't have to worry about the capital gains. But during life, if you want to make gifts to charity, those appreciated assets would be a great giving tool.
Thank you. Fran is asking, are spouses automatically given power for financial and medical decisions when married without a POA in place?
It depends on where you live, but technically, no.
Mm, great. Heather is asking, what happens to beneficiary designated accounts if both spouses die at the same time?
Ah, um, so if you named your spouse, first of all, people rarely die at exactly the same time. So I had a probate where there was a plane crash and one beneficiary was sitting in front of the other beneficiary. So it was determined that the one in front died before the one in
Mm,
back. Sometimes in wills, we say that you have to survive 30 days. So we don't have to do that. You have to survive each other for 30 days. Um, so we don't have to do that kind of forensics. But on a beneficiary designation, if they're both deceased, then you go to the contingent beneficiary on both accounts. And so it's important to have a primary beneficiary and a backup beneficiary. If you don't have that backup or contingent beneficiary, Usually the account contract says what happens. It gets paid either to your estate or to your heirs at law.
Great. Follow-up question from Fran. So what is the default if no beneficiary is listed on an IRA at death? They died in Washington. Sorry,
Yeah,
did you
that
just
would
answer that?
be determined in the contract. It would either be the estate or which could be their beneficiaries, which could be the will. And if there's no will, then state law determines who your heirs are. Or the contract says it goes to your heirs at law. And your heirs at law are this big table. If you have a spouse, community property goes to your spouse. Separate property goes half to your spouse, half to your descendants. If you don't have any descendants, a portion would go to your siblings or parents. If you don't have any of those, it goes all to your spouse. So there's a table that gets followed that determines who your heirs are.
Um, can you tell us some common pitfalls that you see clients enter when they're doing estate planning and how can they avoid that?
I think the biggest pitfall is the assumptions that people make, that they assume that the law will carry out their wishes, which, unless their wishes align with the law, that's not going to happen. Um, they forget that people argue. And so,
Hmm.
even if your estate, you only have kids and it would all go to your kids if you died intestate, you still need to name someone to carry that out. And kids can fight about anything, people can fight about anything. So, people assume, oh, my kids will divide up the tangible personal property. No one's going to want any of those paintings. They're going to sell them all. I can tell you, they're all going to want all the paintings. Um, and they're not going to agree, even if there are three paintings and three kids. So people assume, we assume that everyone's going to get along and make rational decisions. And we forget that grief is in that mix and it makes us illogical and it makes me illogical and it makes my family illogical. We're no different. And so assuming that everyone is going to behave well and logically under stressful conditions is it just doesn't happen.
I think you mentioned something about this earlier in your presentation, but there's a question, how often do you generally recommend clients review their will or estate plan? I assume it depends on life phase, but just curious as a CPA advisor checking in on this with their clients regularly.
Yeah, and I think you need to check in with your CPA every year. I don't think you need to check in with me every year or every 3 years. But if you add a family member, lose a family member, change your marital status, change your employment, you're retired, those things are worth talking to your estate planning lawyer about. And I want to add one other thing, and pets. Pets are just as important. And for people who don't have children, pets are key. And you can leave money to someone to take care of your pet if it's an expensive pet with an expensive lifestyle or a long lifespan, a horse, a turtle. You can set up a pet trust and have that money held in trust by a trustee for that pet. But generally, I do assume that someone's going to love your pet and would be willing to take your dog or cat. But it's nice to also leave them a sum of money that would be sufficient for the rest of their life to cover medical care. And if you have a pet, it's just as important as with children to leave information about who their vet is, what kind of food they eat, do they have a special diet, do they have special toys, do they have places they like to play, other dogs that are their friends. Those are important things. And so having that kind of list on hand to go with your pet, the kind of thing you would leave for a pet sitter, it's important to have that for anyone who would take your pet.
Thank you. Two more questions. How do you suggest starting a conversation with kids and grandkids about what's in our estate plan? Any do's or don'ts?
I love that question because right now, family gatherings can be so politically charged that I think talking about dying is a nice break. So, the times of the year, Thanksgiving is really around the corner. Um, you can say, I'm gonna change the topic this year and we're gonna talk about death. And I think some people will be relieved. And I think that you have to just jump in and hold your breath and do it. And I think once you start that conversation, um, it's a lot easier than you think it will be. And I have a questionnaire that I give to clients, and it asks a million personal questions, and I ask those same questions of everyone. So once you jump in on any level with something about, by the way, I want a Viking send off, or I don't want to be on life support. And then you get everyone's attention and you can say, and here's what I'm thinking about in my estate plan.
That's smart.
Um, but just do it.
Okay.
It's so
Yeah.
important. And I think people will thank you for having had those hard conversations.
Definitely. Okay, last question. Can you give us some easy ways to incorporate charitable giving into an estate plan?
Beneficiary designations for your IRAs, um, charitable, if you have annuities, IRAs, anything that's tax preferred that would be taxed if it went to an individual, can go to charity in a leveraged way. You can just leave either a dollar amount in your will to charity, or you can leave a percentage of your estate to charity. I kind of prefer the dollar amount for a lot of clients if they have complicated assets because you don't want people arguing over the value of a particular asset. Um, Sometimes you can leave your business to charity. I've seen specialized assets, race cars. Charities can sell those assets, paintings. Um, a charity's not going to manage real estate. They're not going to manage a company, but they can hook up with different resources to sell them. So if you have a difficult asset that your family doesn't want or doesn't need, and it can't be an asset that they don't want because no one wants it, but an asset that someone might want and has value, you can leave it to charity. Just like that, on the radio, leave a car. You can leave your car to charity. It doesn't have to be a really expensive gift. It's whatever is works for you and still allows for you to care for your loved ones.
Great, great. Well,
Don't don't leave a piano to a charity on another continent. They don't want it.
okay. Good advice, Wendy. Good advice. And thank you so much. Special thank you to Wendy for sharing her expertise and helping make these important estate planning topics so accessible. As a reminder, when you exit Zoom, you're going to see a brief survey. We really hope you'll take a minute to complete it. It really helps us plan for future programs. We're going to send a follow-up email after this. It'll have a link to the recording as well as the slides. And finally, if you have any questions about your charitable giving, whether it's during your lifetime or in your estate plan, I'm always happy to be a resource. I'm a free phone a friend. My contact information will be in the follow-up email as well. So thanks again for being here. We hope to see you at our next Planning with Purpose webinar in February of 2027. And have a great day. Thanks, everybody. Thanks, Wendy.
Thank you.